I have a much more aggressive strategy at these boards than the vast majority of counsel do. Most of the times at these boards, I hear other lawyers say they never call their client to testify at a BOI. I think that's a mistake. There are times when we don't call our client, but the most of the time, unlike a criminal trial where we don't often call an accused or defendant to testify, at these boards, we almost always call our clients to testify. We prep them extraordinarily well. We're preparing them for direct, prepare them for cross-examination, and prepare them for the board members' questions. Because remember, you are asking these board members to keep you in the military. And if you're not willing to take the witness stand, take an oath, and tell them exactly what happened or what didn't happen, and fall on your sword and say, this is what actually happened, I want to stay in the military for these reasons, your odds of winning are significantly lower. And now I may be, unique in that opinion. I see a lot of people do these boards, don't ever call their client, and they lose. And so, well, how the hell do you expect to be retained by a panel of military officers if you don't even have the moral courage to take the witness stand and testify as to what happened and why you should stay in? They're going to look at you. They're going to look at you like a coward for the most part. And the rules on this, again, they apply very differently to criminal trials, at least the way we do this, we do it strategically than they do to these BOIs. Now, clearly there are cases where we have a client who can't testify for a whole host of reasons. And I've done BOIs, and I've even won a BOI recently at Fort Meade where a client did not testify and we won. So this advice, you have to do an analysis for each client. But I will say that at these boards of inquiry, the vast majority of them, we will call our client to testify, have them extraordinarily well prepped. And what I find is these recorders or these government prosecutors, again, they're not prosecutors, they're called recorders, they don't know what the hell to do because you've got a major, or lieutenant colonel, or a colonel on the witness stand, and they're telling what happened or what didn't happen, and they're talking about their career and why they still add value to the military. And the government counsel on the other side has no idea what the hell to do, and every time they ask a question, they dig themselves a deeper hole. But most importantly, at these boards, you have to understand that the three board members, because it's a fact-finding mission that they have, can ask questions, and they have to draft written findings of fact. And so if they have a question that they want answered and your client can successfully answer that or wither a barrage of questions from the board members, and they know you, like you, and trust you at the end of this hearing, you're almost always going to win that. And so you have to have a lawyer that knows how to prepare you, how to, practice this, how to cross-examine you. And if you can do that, call witnesses, fact witnesses, call your character witnesses, and if you can successfully testify at these boards as a respondent, you're going to win a whole hell of a lot more than you're going to lose. If you've been notified of an administrative separation board or a BOI, I want you to understand that you can absolutely fight this, regardless of whether your GOMAR was permanently filed or you're previously found guilty at NJP or Article 15. If you have a right to a board, get in front of these board members and fight. You can win these cases at a board. We do this routinely. If you want to have a conversation about how to do that, give me a call, 813-669-3500, or look at the information we have on our website, www.bileckilawgroup.com.